Welcome to the Sound of Ideas from IdeaStream Public Media. I'm Stephanie Haney. Thanks for being with us today. The rule of law is a crucial concept to democracy. It's the idea that every person, organization, and government entity must follow the same laws, no matter where you live, how much money you have, or what title you may hold. Ensuring the equal application of the law requires an independent judicial system, with judges who are expected to be an impartial and nonpartisan check on the executive and legislative branches of government. Even though judges are instrumental when it comes to upholding the law as it is written, there are things everyday Americans can do to support that effort. I'll be moderating a conversation about this today at the City Club of Cleveland with retired Ohio Supreme Court Chief Justice Maureen O'Connor, who is a Republican, and former Ohio Supreme Court Justice Michael Donnelly, who is a Democrat. They've come together to speak out about the importance of the rule of law to preserving democracy as our form of government. Now, the City Club event starts at 12 p.m. I do have the justices with me now in studio for a preview of the event. This is our latest installment of our Law of the Land series, where we look at legal issues that affect our everyday lives. So first, let me welcome our guests. Hello, Chief Justice O'Connor. Thanks for being here.
My pleasure. Good morning.
And Justice Donnelly, welcome to the show.
Thank you for having me.
If you're in our audience and you want to join this conversation, please give us a call. That number is 866-578-0903. You can also send us an email at soi@ideastream.org, or you can message us on Instagram at The Sound of Ideas. Now, as we start this conversation, we know that the late Supreme Court of the United States Justice David Souter had made comments that Americans need a better understanding of civics, or power could consolidate, and lots of things that the founders of this country didn't anticipate would happen, could happen. So, Justice Donnelly, I want to start by asking you, why is protecting the rule of law so important? What happens when we stop making sure we're protecting the rule of law?
Well, the rule of law is the bedrock of our democracy, this notion that the framers contemplated when they designed our country, that in a country where you're going to have people with disagreements, the rule of law means that once policy becomes law, we all agree to follow that law. Whether you agree with it or not, you can always work to change laws, and there's certainly a lot of laws that should be changed. But the law is a restraint on governmental power that our framers believed was very important. And you referenced David Souter. Your listeners can Google a warning that he issued way back in 2012 before what was happening today could never have been contemplated by most reasonable people in this country. And he worried about if things became so bad that someone would come along and say, give me all the power and I will solve the problems. And that power would rush out of the institutions, and that includes not only the legislature, but courts, who are there as a backstop against overreach by any of the other branches.
And as I mentioned, we will be having a conversation at the City Club this afternoon. If you are not able to be there with us in person, you can stream that starting at 12 p.m. today at cityclub.org. You will hear that warning from Justice Souter. We will play a clip of that in case you're interested in joining us for the conversation as it continues. Chief Justice O'Connor, so I would like to ask you, when it's working perfectly and the rule of law is being upheld, how do the three branches of government interact, and what's the judiciary's role in protecting the rule of law?
Well, good morning, and thank you for the question. Before we get to that question, I want to just tag on to the previous question that our founding fathers anticipated a strong, one of the three branches taking over, presumably the executive, and they talked about it, and they contemplated it, and so they put these systems in place, the three branches of government and the duties that were attended to each, to thwart the one branch having too much power and riding roughshod over the other. And I think we can see that happening right now. Why it's happening is subject for probably another question and answer. But they did foresee something as and were just united in their opposition to that. So when things are all going well, what are the duties? What are the responsibilities? Obviously, the legislature creates the laws. It's supposed to be a deliberative process. They're supposed to take into consideration many, many different points of view. They're supposed to work together. And when I say that, you hear the phrase across the aisle. That's exactly what should happen, no matter what the minority, majority parties are. And then come up with legislation that they believe is best for the citizens of this country that will be affected by that law. The law is passed. It is, out there, and say there is a disagreement about it. There's a lawsuit that is involved, whether it's a criminal case and someone is convicted in a court of law, which is, what would happen, or it's a civil matter and they go to court and sue, and of course one wins out. What do? They have the right to appeal. So they appeal to an intermediary court, and then if one party isn't satisfied with that, they can appeal to the Supreme Court. So the appeals process is what is so fundamental to the judicial oversight and the duties of the judiciary. The judiciary has the final word, though, on interpreting and applying the law. Sometimes the law is ambiguous. Sometimes it's written in a way that, needs to be interpreted. Sometimes words in the legislation need to be defined and to be applied. That's what the judges do. Judges make all kinds of decisions. Some are popular, some are unpopular. No matter what the decision is, again, there is that appellate process. And then, of course, the executive is the implementer of laws. And the executive, in many times has to defer to the justices or the judiciary or the legislature. If there's an unpopular law out there, if there's a law that is shown to be flawed, then it's back to the drawing board in the legislature to try and fix that. It's not for the judges to rewrite the law. You've heard the phrase legislating from the bench. That's an overused phrase, and it's thrown out there, just like the words activist judge. They're meant to be attack words. And oftentimes, most times, it's used, that's not the case at all. But courts do make unpopular decisions. And unfortunately, that's what the law demands. And as my colleague has mentioned, it's up to the legislature to fix that.
Justice Donnelly, in your view, what are some of the warning signs that we're seeing that you think the late Justice Souter was referring to that are now causing the situation where you two are coming together to say we need to protect the rule of law?
Yeah, well, the warning signs started for me in January 2025 when a flurry of executive orders were issued that most legal commentators said, well, these will never fly because the courts will act as a backstop and declare that these are violating the Constitution. And a very respected Judge Michael Ludig nationally wrote an opinion in the New York Times that said, the courts will strike these down. And then 2 months later, he wrote an article in The Atlantic that said, the end of the rule of law in America, because he saw that the institutions the orders were not being followed. And that's the most concerning thing for me as a jurist. There were plenty of times when I was at the Ohio Supreme Court, when I was in the dissent, I disagreed with the majority, but I understood that the majority decision was the law. And as Chief Justice O'Connor mentioned, sometimes when you follow the rule of law, it's unpleasant. It leads to unpleasant results. But that's our duty to follow the law. I had no allegiance to the Democratic Party, even though I was supported by the Democratic Party. Judges' sole allegiance is to the law. And there's a number of things happening in this country flying under the radar. There's an attempt by the DOJ to immunize DOJ attorneys from disciplinary conduct if they allegedly violate the rules of professional conduct. A group of historians are suing the present administration because they are relying on an opinion, not a court decision, that they don't have to turn over information that is mandated by law, a law instituted after Watergate, in order to make sure that we have an accurate record of history. These kind of things are kind of flying under the radar, and both Chief Justice O'Connor and I are very alarmed as jurists, because when you see court orders being disobeyed, we know democracy is under threat.
I want to remind our audience that we are talking about the rule of law today and the importance of protecting the rule of law when it comes to protecting our form of government, which is a democracy. Our guests today are retired Ohio Supreme Court Chief Justice Maureen O'Connor and former Ohio Supreme Court Justice Michael Donnelly. If you want to be part of this conversation, the number is 866-578-0903, and you can email us at soi@ideastream.org. This is a preview of a conversation we'll be having at the City Club of Cleveland this afternoon. Chief Justice O'Connor, is there anything you would like to add in terms of warning signs that you're seeing that this warning from the late Justice Souter is coming to pass?
I would say the complete lack of accountability. That people are just, when I say people, our institutions. I think our executive branch and our legislative branch are just running roughshod over accountability. There is no accountability. And all three branches of government can only function if they are accountable to the citizens of this country. All power resides with those that are governed, our population, and it is up to these institutions to be accountable to them, and that includes the judiciary. You know, as my colleague said, we're not beholden to any political party or any institutions that are, supporting us, et cetera. It's judicial independence is the phrase that you hear so often, and sometimes that gives the wrong impression about the judiciary. It gives the impression that they are above, following anybody's advice, or and that's not what judicial independence means. It means it's not freedom from accountability. It's freedom to be free of improper influence. In other words, you don't take your politics on the bench, your religion on the bench, what social clubs you belong to, what your friends or your, supporters might be writing to you in letters, which is something that happens. I got a letter once when I was on the redistricting cases. Well, I got a series of letters, most of them overwhelmingly positive on what we were doing. But I'll never forget one letter, and the woman said, "I voted for you because you are a Republican, and you are not voting like a Republican." In other words, I wasn't following the will of the Republican majority in the legislature. I took that as a compliment, quite frankly, that I'm not voting like a Republican. I'm not voting like a Democrat either. I'm voting like a Chief Justice. And that is what is called for, no matter what level of the judiciary you are, is that independence from influence, but not independence from the rule of law.
We have an email from an audience member that I want to ask about now. This is something that the audience member would like each of you to comment on, and it's the 2024 ruling from the Supreme Court in Trump versus the United States that former presidents have absolute immunity from criminal prosecution for actions within their core constitutional powers and at least presumptive immunity for all official acts. This was a 6-3 decision. So what does this do for protecting the rule of law? Can you talk about this decision? Justice Donnelly, I'll ask you first.
Yes, I think legal experts, when that decision was issued, rightfully questioned the analysis. That's the thing in the judicial system. When you make a decision, you have to show your work. You have to show your analysis on why the law applies. Now, I grew up in the country being taught that no one was above the law, including the President of the United States. And when you have the Supreme Court of the land issuing a decision saying that's not true, you look to the reasoning. And I think the reasoning has been properly criticized in that decision. And that's an example of some of the norms that are being broken at a breakneck speed in this country. And if we don't pay attention, we'll still have a government, but we will no longer have a democracy, and we will no longer have the freedoms that are protected by the Constitution and the laws of the United States.
Chief Justice O'Connor, what are your thoughts on that decision and the impact it has on the rule of law?
I agree with my colleague about that it is ill-advised, and it is a decision that empowers, gives the sense of empowerment to the executive branch, in this case, Donald Trump, but to the executive branch that it takes away the accountability. And it's just what I was speaking about, in the prior question. It appears that the president is not accountable in the court of law for what is done in, quote, his official capacity. And that can be distorted in so many ways. That's the problem with this decision. It's too all-encompassing. It should have been much more narrowly drafted. Now, this is an example of an opinion by the United States Supreme Court, and they are the last stop on this, this journey of legal determinations. That is not to say that they're always correct, okay? There's some phrase that, we're not right because we're, I forget what's the phrase, Mike? We're correct because we're last.
Right.
We're not correct. We're not last because we're correct. We're correct because we're last. Or it's something. Anyway, I butchered that. But again, the accountability. So what's to be done? Citizens need to be informed. Don't be overwhelmed. Be informed about what is going on. Be careful of your sources of information. That's why programs like this are so valuable. And I just applaud NPR for everything that they've been doing in trying to educate the population. And it is so important to have the correct information and to formulate your opinions. Now, normally, you would go to Congress with your opinion about a Supreme Court ruling and say, what can be done? Okay, what could be done? If it is the interpretation of a law, then that law can be changed through Congress. Or if it is something based on the Constitution and it's determined that that's, and the population does not like that interpretation, they think it's wrong, they can pass another constitutional amendment. Very difficult thing to do, I know, but that's the recourse that our founding fathers have embedded in our system. But I just want to say that, not all opinions by the United States Supreme Court are opinions that I think were soundly decided, but I would obey them if they affected me, even though I disagreed with them. Another example is Citizens United. That is a case that opened the door wide, so wide, for dark money. And that's that topic I'm sure you've had conversations about. But that's another example. Legislature, Congress, do something about it. And they will not because they're beneficiaries.
Dark money being the ability for organizations to donate money to political causes through super PACs without necessarily revealing who they are or where that money is going. Thank you for bringing that up, Chief Justice O'Connor. I want to ask you to go back to something you mentioned earlier, Justice Donnelly, is the fact that it seems that court orders are not being adhered to. What's the recourse for that if the executive branch is not following court orders? I know that there's the U.S. Marshals that the judiciary has at its disposal, but tell us more about that. What is the recourse? What does a citizen do? What do you call for in that instance?
Well, in a functioning democracy, the answer would be a contempt of court holding. But when you have an entire branch of government that has decided to not follow a court order, that is way more problematic. Because we don't have an army in the judiciary. We've always had a culture of legality that you don't have to agree with the decision, but you have to follow the decision. One example of that was when the landmark decision of Roe v. Wade was turned over, and with the Dobbs decision, and they said that was now a matter for the states. You didn't see an uprising in this country. There were plenty of people who rightfully disagreed with that decision and the analysis in it because it seemed to break with long standing principles of stare decisis and something that keeps stability in the country. And there's people who validly had disagreements with Roe v. Wade, but when that was overturned, the people followed it, and you see it being followed in states like Kansas. Ohio responded to it in a legal manner. But when you have a federal judge ordering someone who was not ordered not to be taken out of the country to a foreign prison in El Salvador and ordered back, and an executive branch responding by saying, we're not going to do that. That's a problem. That's a constitutional crisis.
What would you recommend a citizen do in this situation?
Well, all we can do is what's been effective in other countries when democracy has been threatened by the rise of authoritarianism. What has been effective is that people form broad coalitions with people that you may disagree with on policy, but that you value a country that is built on the rule of law and not men. That's the difference between a democracy, because law restrains power. In another form of government, in a authoritarian form of government, power is not restrained. It's in the form of the executive, and you have no recourse on how it's exercised.
If I may also add something to that, it is frustrating, and the legal system can be slow, and it can be ineffective, quite frankly. If all three branches aren't playing the part the Constitution has scripted for them to do. In this country now, we have a Congress that is not playing their part. Okay, they're not using law. They're not making law that restrains. They're looking the other way. That is extremely unfortunate. Now, what's to be done when, as Justice Donnelly mentioned, people coalesce, groups come together, they're moving the same direction, and that direction is to change by the vote. And that's one of the most magnificent things that we have in our country, is the use of the vote. And again, you don't have to agree 100%, but you have to agree that the rule of law is supreme, and we need to do something that's going to enhance that. So what do you come to do? You vote, and you then vote the people out of office that are ignoring the Constitution, that are part of whatever the cabal is that is trying to weaken democracy. You look at what happened in Hungary just two days ago. Orban was taken out of office. Never did people think that would happen, but it did. And why? Because of population. The population came together and said, enough is enough. We cannot live under a government, and we cannot live under this authoritarian approach. That is a great example for us here in the United States.
Something that we saw recently with this administration is we did see the United States Supreme Court taking a look at an executive order that was meant to limit birthright citizenship. And that was one of the executive orders that was passed in the initial days of President Donald Trump's second presidency. So that executive order conflicts with the wording of the U.S. Constitution. And I want to ask you about this. I'll ask you first, Chief Justice O'Connor. President Donald Trump has been openly criticizing the United States Supreme Court. He also sat in on oral arguments. Mm-hmm. That's the first time that's ever happened. Is there significance to that when it comes to protecting the rule of law?
Significance that he is present in the courtroom while the case is being argued. That is in keeping with his nature to be a bully, to intimidate, and that's why he was there. Also to be a showboat, that. He's a narcissist that has to have, all the attention. Take the attention away from the 9 decision makers that are up there on the bench, the litigants that are arguing probably one of the most important cases of their life, and interfere with that just because you can. So will that sway, will that change the jurists in their deliberations? I think nothing could be farther from the truth. It will not. It will not. Now, let's just remember that federal judges are judges for life. Nobody can remove them except for, criminal proceedings, dereliction of duty, that sort of thing. But that, again, has to be an impeachment process. Not going to happen. So intimidation is the last thing that will work. It'll never work on a judge, of the United States Supreme Court, and it should not work on any other judge in any level in this country.
What do you think about that, the presence in the courtroom for the oral arguments, Justice Donnelly?
Yeah, well, people should question why he's the first president to ever do something like that, because it shows a lack of understanding, at the very least, that his presence, whether he was there or not, should have no effect on the analysis on that decision. Now, let's try to remember when that executive order was issued. People thought, there's just no way that's going to even fly. The law is so clear on this. We've all grown up. If you're born here, you're a U.S. citizen. The fact that it made it there to the court is astounding. But what is even more concerning is when decisions come out that the president disagrees with, he disparages the court, which is very dangerous. When you start hearing about decisions that you either agree with or disagree with, and your first instinct, as a lot of people in the citizenry now rely on, they say, who appointed the judge? Is it a Trump judge? Is it an Obama judge? Is it, and that's a dangerous threat to the rule of law when the public believes that the decisions are based on the proclivities of the politics of whichever president appointed that judge. That's a threat to the rule of law.
And it's also a threat to the judges individually when you see the president berating the highest court in the land, the members of the highest court of the land, saying things like their families ought to be ashamed of them. That sort of rhetoric. And people embrace that. People who are, followers and, you look at the high incidence of threats against the judiciary, and I mean physical threats against the judiciary, and the number of judges who have been shot or killed or a family member killed because of an attack at their home or their court or whatever. We had one in Ohio not too long ago. Fortunately, the judge happened to be armed and was able to return fire, and so too was a probation officer that was there. But the judge was injured. He was shot, and it was a life or death situation for him. So, this is real. This happens here in Ohio. The threats that come in the mail. Fortunately, when I was on the Supreme Court and Justice Donnelly was on the Supreme Court, we had a staff that monitored our mail. It's unfortunate that you have to have a staff that is going to open your mail just to make sure there's nothing yet in it that would be a danger, because that's a reality now. That is a reality, and it was not like that in the past.
If you're just joining us here on The Sound of Ideas, we are talking about the rule of law. Our guests today are retired Ohio Supreme Court Chief Justice Maureen O'Connor and former Ohio Supreme Court Justice Michael Donnelly. We're going to take a quick break. We do want you to be a part of this conversation. The number to call to do that is 866-578-0903. The email is soi@ideastream.org. So we'll take a quick break. We'll come back in just a moment and continue this conversation about the rule of law. This is The Sound of Ideas. Stay with us. Hi, I'm Stephanie Haney. This is The Sound of Ideas. Thanks for staying with us. We are talking about the rule of law today and the importance of the judiciary in protecting the rule of law and preserving democracy. Our guests today are retired Ohio Supreme Court Chief Justice Maureen O'Connor and former Ohio Supreme Court Justice Michael Donnelly. If you want to be part of this conversation, the number to call is 866-578-0903. You can also email us at soi@ideastream.org, or you can send us a message on Instagram at The Sound of Ideas. Right before the break, we were talking about the appointment of judges and the fact that federal judges are appointed for life. So I'd like to ask each of you, and I'll start with you, Chief Justice O'Connor, your opinion on appointment of judges by political leaders. You know, some judges are elected, federal judges are appointed. Does the appointment by a political leader, as Justice Donnelly was referring to, some people will question, is that a Trump appointee? Is that an Obama appointee? Does that do anything to hurt the faith in the impartiality of the judiciary and the preservation of the rule of law?
That is a question that, I've been asked before, and it's one that I look at how judges are appointed here in the Ohio, as opposed to the other, states and territories. We have an elected system, always have had elected system since the mid 1850s. In recent, and when I say recent, the late 1930s, and then fast forward 50 years to the late 1980s, that question was put on the ballot to voters in Ohio. Do you want to do away with the elected system and have an appointed system? The same results, 50 years apart. 2/3 of the people overwhelmingly said, no, we want to keep our elected system. So that we have that. That is our norm here in the state of Ohio. So we don't have now we do have an appointment. If there's a vacancy, the governor will appoint someone, but that person then has to stand for election at the next general election. Other states, as you mentioned, they come with an appointment from the governor, and they only stand for a retention election. In other words, the voters give them a thumbs up or thumbs down on whether they're doing a good job. Overwhelmingly, the judges are retained in those situations, but not always. Depends on if there is a collective resistance. And that happened when judges in Iowa did a abortion decision, and those justices lost their positions when the populace voted. So and again, that's what happens in an elected system. Is one better than the other? They both have their benefits and they both have their flaws. The thing of it is, as I mentioned, the people of Ohio makes those decisions for us, and 50 years apart, the same results, 2/3. We want to keep our judiciary. And so what does that mean? It means the voters have the obligation to learn about the candidates. You don't vote without, it's a privilege, okay? It's a right. But it's also an obligation. And an obligation is encompassing duties, and that duty is know your candidates. Don't just look at a political label. It's important to be an informed voter.
And speaking of that, we did get an email in from Josie from Euclid. Justice Donnelly, I'll ask you if you have any insight on this. Josie wants to know where a voter should go to get the best information, particularly on judges, before casting a ballot.
Well, the Bar Association has an organization called Judge for Yourself, and that's run by the lawyers who appear before the judges, and they can tell you firsthand whether the judge is moving their docket efficiently, whether they're treating people with respect. But as Chief Justice O'Connor just said, I fully agree with her. If I could wave a magic wand and we were going to maintain an elected judiciary, I would make it nonpartisan. Mm-hmm. I've traveled all across this great state. I've spoken to Republican groups, Democratic groups, independent groups. They all want the same thing from their judiciary, and that's fairness, judges who follow the law. They want maximum transparency and maximum efficiency, and that is what they want. We are referees, and we should be not only impartial in how we conduct our duties, but also maintain that appearance of impartiality, because that's the lifeblood of the system, that the citizens believe that the judges are going to be not following their whatever political proclivities may be in a certain case, that they will be following the rule of law. That appearance of impropriety or impartiality is of utmost importance.
Let's talk about something that is relatively new here in the state of Ohio, and we talk about the party designation that is now present when voting for a statewide judgeship on a general ballot. Now, Ohio had an interesting system before where if a judge was running in a primary, there was party affiliation, but then no affiliation on the general ballot. Now, as of 2021, which is something you did not have to contend with, Chief Justice O'Connor, because you retired from the bench in 2022 as the longest standing woman for a statewide elected office. Now, for you, Justice Donnelly, you did have to contend with that. In your most recent reelection effort, you had to designate a party on the ballot. Your reelection effort was not successful. So I want to ask here, do we think, I'll start with you, Chief Justice O'Connor, do you think it's possible for voters to know the party affiliation of a judge and then trust that that judge won't decide cases on a political basis? What does this do for the rule of law and confidence in the judiciary?
I think it undermines confidence in the judiciary. This all started when several Republican judges and one justice were unsuccessful when their designation was not on the ballot. They should have won, according to the politicians, they should have won in districts that they lost. So how are we going to fix it? We're going to fix it by putting the political designation on the ballot, and we'll do it for appellate courts, our intermediary courts, and we'll do it for the Supreme Court. And that's going to guarantee that our party is going to have judges that are of our party. That is the antithesis of what the Constitution and our legal norms would dictate. But again, politics and politicians being as they are, that's what we have here in Ohio. So does it send a message? I always say it sends a cue to the voter, but it's a miscue. If they believe and that judge behaves in a way that does not respect the political designation, then good. That if they respect the person, they respect the law, they respect the case in front of them, they respect the jury. That's what a judge does. But they don't bring, as I said, their political affiliation onto the bench. But it makes the public think that they will. There's a chance that they might be influenced, that a political party boss could whisper in their ear. That happens in other countries. That happens in, authoritarian countries. It doesn't and should not happen here in the United States. It would be an ethical breach, quite frankly, for a judge to do that.
And Justice Donnelly, you did have to contend this. You had to run a campaign where you were forced to have that party designation in the general ballot. It's actually being challenged now. There's a lawsuit against it. A current person sitting on the Ohio Supreme Court, Justice Brunner, is challenging this. So what are your thoughts on it in terms of whether it's helpful, not helpful for the system?
I don't think it's helpful at all. I remember during the redistricting cases, one of the newspapers had a headline that said, longtime Republican Chief Justice O'Connor sides with the three Democrats. And I called the editor and I said, that's an accurate statement, but it really is a disservice to the public because that's not how we arrived at, we don't barter, we don't horse trade in the judiciary. As Chief Justice O'Connor has said, it's not a team sport. We independently arrived at the same conclusion, and we had to happen to be in the majority. Now, in 2018, when I had no party label, I won the state by 61% of the vote. I'm not going to say that's because everyone knew who I was, but I can say this. I was very proud of the bipartisan support I received from both Republicans, Democrats, and independents because my message is I have no allegiance to any political party. My allegiance is solely to the law, and we have to get back to that. Chief Justice John Roberts has said we're there to call the balls and strikes. And, there's a reason why an umpire wears black and doesn't wear any team logos when he's calling a Guardians game, because you want to trust that the people who are entrusted with making sure the laws are followed in any particular case are doing their job.
I want to ask about this, which some of the people who supported that change, adding the party designation to the statewide judicial ballots, had said that the reason for it, or a reason for it, was ballot drop-off, with more than 1 million Ohio voters in 2020 leaving 2 Supreme Court races blank. So this was an effort, as they said, to give more information to voters. So if that's not necessarily the best answer, is putting the party affiliation there, what do you do to get voters to participate in those judgeship elections. Justice Donnelly?
Yeah, I think civic education about the role of the judiciary is very important from an early age, and that's what Justice Souter said in his remarks, that we need to get back to a place in this country where people understand that the judicial system is where people go to resolve disputes. It's not a political system. It's there where people who are entrusted with that privilege as serving as judges, they do their job by being adherence to the oath of office, and that is to follow the law wherever it takes you. There are plenty of decisions that Chief Justice O'Connor and I could tell you about. We didn't like the result, but we had to follow the law. And the legislature is, if there's a law that is rendering an injustice or needs to be changed, that's a job for the legislature to take care of.
I would challenge the rationale for this law. You know, you mentioned that somebody said this is going to cure voter drop-off. That was not the reason. That's like putting lipstick on a pig. And that's exactly what that phrase is saying, this is going to assist with voter drop-off. Yeah, you may have more people voting, but they're voting because, they're trusting the judge to be of the same political party as they are. They're voting under an assumption of a presumption that a judge can be biased, and they're voting because they think that's a good thing. You know, again, we have to have better civic education in this country to understand what our founding fathers intended, what our documents mean, and the role of the actors in the political, and the obligation of our citizenry, is in the election system, in monitoring and being aware, as I said, not being overwhelmed, but being informed. So to say it's voter drop-off, I know for a fact that's not the case, because I had conversations with politicians from the legislature who tried to encourage me to support this when I was Chief Justice. And their rationale was, we lost a lot of, judges that we shouldn't have lost, et cetera. And now look at the balance. We got too many Democrats on the bench. We have too many Democrat judges. So you can, figure out from that the people who wanted this was the Republican Party, who are the majority in the legislature. My response to that was, that's democracy. The election of the judiciary is democracy in action, just like for any other elected official. And you're trying to put your finger on, or your thumb on the scale, and that's exactly what this R and D on the ballot is there for.
For anyone just joining us here on The Sound of Ideas, we are talking about the rule of law and the role of the judiciary in protecting the rule of law, the idea that the law as written should be equally applied to all people consistently. And our guests for this conversation are retired Ohio Supreme Court Chief Justice Maureen O'Connor and former Ohio Supreme Court Justice Michael Donnelly. If you want to be part of this conversation, the number to call is 866-578-0903. The email is soi@ideastream.org. We'll also be continuing this conversation at an event at the City Club of Cleveland this afternoon. If you're not able to be there in person, you can live stream that event starting at 12 p.m. We did get an email in from Sarah. Sarah writes, these are Sarah's words. Your guests are wrong if they think judges can't be scared, including the Supreme Court. They're humans too, so they have fear for their own safety and for their families. And I imagine they're afraid of losing Secret Service protection, like Dr. Fauci did, at the whim of this madman in the Oval Office. The only reason he visited the Supreme Court was because he has the power to engender fear in this very exclusive group. This is from Sarah in Highland Heights. We started talking about a bit earlier about the fear for danger for Supreme Court justices and judges in general. What do you think about that comment that the Supreme Court might actually be scared? Should we be concerned about that, Justice Donnelly?
Well, I do agree with the premise that judges are human and certainly susceptible to fear, and that if we allow a culture where judges are indeed fearful if they render a certain position, even though it adheres to what the law demands of them, that can permeate their decision making, and that's something I think she's raising an alarm in that email that should be taken seriously in this country.
Chief Justice O'Connor, do you have thoughts?
I do. The federal judiciary has security in place for them, especially the United States members of the United States Supreme Court. When I say security, I mean they're marshals that go with them wherever they are appearing, and that is a deterrent. And in some cases, or many cases, the Marshal Service and the people that are in place to protect them have done their job, and they've thwarted people who would harm. There's security systems on people's homes that are part and parcel of the federal judiciary. So the federal judiciary, yes, anybody in a job on the bench has the potential of having a backlash. Whether that backlash turns violent is another matter. The state courts are not as protected. The state court judges not as protected. We had security at the Supreme Court. It was a building that had to be secured, a staff of over about 165 people that needed to be protected, and then you have the members of the Supreme Court and our immediate staff. Yes, there have been incidences of people trying to breach the security of our building, but it was handled. It was handled. What about a judge that's out on their own? Because we don't, when we're on the court, don't travel with security when we're going to the grocery store or any of your normal places that you go. And we have not had an incident of violence against a Supreme Court justice here in the state of Ohio. As I mentioned, a trial court judge was shot, and that was by a party. They felt emboldened. I'm going to make a decision here to kill this judge so he will not render a decision against me. I mean, why would somebody think that that's the solution to your legal problems? It's because the rhetoric that has been, increased since 2016 against the judiciary gives rise to the thought that, and then they act on that thought, that judge is biased and has no business being on the bench, so I'm going to challenge that, and I'm going to challenge it in a violent way. It's disheartening, but that's what we're up against now.
We have just a couple minutes left before we continue our conversation in a bit at the City Club of Cleveland. So I'll ask both of you now, what should people do if they're concerned about this? What can they do to take action? Is it civics education? Is it voting? Should people move? What should people do? Justice Donnelly.
Sure. Well, I've, along with Chief Justice O'Connor, have joined forces with a nonpartisan group called Ohioans for the Rule of Law, and we are trying to form that broad coalition of both Democrats, Republicans, independents who want to return to a democracy that believes that its bedrock is the rule of law. So that's something you can join. Another thing is you can call out when you see norms being broken. Just in the last 2 weeks, we had a decision from the Ohio Supreme Court that would allow judges for the first time to endorse other candidates. This should be being talked about. Like when I became a judge way back in 2005, it was told to me early on that if you're going to be a judge, you must maintain impartiality. So there's going to be certain restrictions on your activity so that you don't give the public the idea that you are just like another politician.
Mm-hmm. Chief Justice O'Connor, what would you like to add to that in just a moment here?
I think the civic education is just essential, absolutely essential. I think our educators need to partner with lawyers and members of the judiciary and understand what civics should be taught in the school, and from an early age. I'm talking primary school, that you introduce these concepts and they know who these positions are. Now, people that are out of school and, not having received that kind of information, they can still, as Justice Donnelly said, associate yourself with these organizations that are formed. There's some in your community, there might be some in your neighborhood. Seek them out and inform yourself.
Thank you very much. I want to thank our guests, retired Ohio Supreme Court Chief Justice Maureen O'Connor and former Ohio Supreme Court Justice Michael Donnelly. Thanks for the time here on The Sound of Ideas.
Thank you very much.
My pleasure.
This conversation will continue this afternoon at the City Club of Cleveland. If you're not able to be there in person, you can live stream that at cityclub.org starting at 12 p.m. You can also find that link on ideastream.org/SOI. That wraps up this part of the conversation. If you missed any part of today's show, we'll rebroadcast it tonight at 9 on 89.7 WKSU. You can also find The Sound of Ideas wherever you get your podcasts and on YouTube. To get the last word on today's topics, please email us at soi@ideastream.org or find us on Instagram at The Sound of Ideas. Yesterday, we talked about gardening and how to make the most of planting season, including a lot about invasive and native plants, and Cynthia and Euclid emailed in. For those interested in identifying invasive species in their own yards, Nature in My Backyard is a free program sponsored by the Audubon Society and the Master Gardeners of Cuyahoga County. Yard owners can invite a native plant expert to visit their yard for an hour, identify invasive and native plants and non-natives that are not invasive, and offer suggestions for replacing invasives with natives. That was a mouthful. Thank you for the tip, Cynthia. Tomorrow on The Sound of Ideas, we're breaking down this year's class of the Rock and Roll Hall of Fame inductees. We look forward to having you back with us. Thanks for keeping the conversation going. I'm Stephanie Haney. We'll see you tomorrow.